Ladies and gentlemen, with the spotlight turned towards Kashi, where in the entire matter of Shringar Gauri and the entire Gyan Vapi Parisar, there was an application filed by the Hindu Paksh where they wanted carbon dating or any other form of trying to establish not just what is there in those areas, visible and invisible deities, but more importantly, the age of the structure which is present there. The Hindu Paksh believes it is Shivling, it is the Adi Vishweshwar, which is there in the area that was designated a Wazu Khana. The Muslim Paksh believes it's a fountain. Now, ahead of the hearing today, the Muslim Paksh, CNN News 18 was able to access the application or the counter of the Muslim Paksh, which said that this area is already cordoned off or blocked by the Supreme Court. This is actually a fountain. There is no need for carbon dating or any other kind of measurement because it is it is not required. They've also specifically tried to put their finger on carbon dating, saying that carbon dating is done on something which had life and does not have, or to prove whether something had life or not. So it does not apply here. However, the Hindu Paksh had modified their application and said any form, even if it is not carbon dating, any form of a scientific experimentation or ratification which can determine what that structure is, the age of that structure and the nature of that structure, and that they said could be done only by the ASI or the Archaeological Survey of India. So that's where things stand. Let's go across to the petitioners from the Hindu Paksh, Vishnu Shankar Jain and Hari Shankar Jain ji. Namaste, gentlemen. Thank you very, very much. What happened in court today, Vishnu Shankar Jain?
See, today we had already moved an application and argued it on 22nd of September, where we had asked for a scientific investigation to ascertain that how old and what is the age and nature of the Shivlingam which has been found on 16th of May. So on that application, the court had invited objections from the Muslim side, and the Muslim side had submitted their objection today. And the interesting part of this is that they had said in the court today that it's a fountain, and in their affidavit also before the Honorable Court, they have said that this is a fountain. So now the question which arises for consideration is this, that if one side of the matter is saying it's a fountain, and the other side believes that it's a Shivlingam which is found. So what's the mode of ascertainment of what is the nature of this object, whether it's a Shivling or it's a fountain? How can it be ascertained? Our respectful submission was that it can be expert through an expert opinion under section 45 of the Indian Evidence Act, and therefore the court must call upon the ASI and constitute a commission of the Archaeological Survey of India, including the petitioners, to go and see that by which modern technology the age and nature of this Shivlingam can be ascertained. And for that matter, the Honorable Court has reserved its verdict, and on 7th of October, the Honorable Court will pass an order on our application seeking an ASI survey of the Shivlingam which has been found.
But Hari Shankar Jain ji, the Muslim Paksh says this area has been blocked, marked out by the Supreme Court. So the Varanasi court is not at liberty to decide what can be done there. Is that a just observation, or do you believe one side says Shivling, another side says fountain, only ASI can decide?
I pointed out to the court that on 17th May, the court has clearly passed an order that district judge will be empowered to decide all the applications. This order was passed on 20th May. All ancillary applications, all miscellaneous applications, whichever may be filed, an entire case has been transferred to the district judge. Therefore, court is competent to decide all the matters, and everything which was said by Muslim side and also by one of the plaintiffs, number one, they colluded and their stand was same, and one, that this application filed by us be dismissed. And I also pointed out that Order 26, Rule 10A of the CPC clearly provides that scientific investigation can be made, can be ordered by the court, and that can be made. Number two, the Shivlingam which has been found, one party says it is otherwise, it is fountain. Naturally, the court or advocates or anybody or no evidence can be produced. It is only this scientific investigation which will prove what it is. Number two, kindly consider, I want to clarify that large number of hue and cry has been made, and it said that we want the Shivlingam be damaged. for carbon dating. No, this is absolutely wrong. We have never said that a carbon dating of any type which may damage Shivlingam be conducted. The only thing is scientific investigation and other constituents of Shivlingam by GPR survey or otherwise. That is misinterpreted. And I want to make it clear that we are doing for the mandir, for the temple, and there is no question and never we can allow the Shivlingam be damaged in any way. And our prayer is very limited and very clear that this area be investigated scientifically by SI. SI has the power, SI has the instrument, as has been said by Honorable Supreme Court in Anajudha case. And they have written that the ASI has the power to conduct every type of investigation.
So you are not saying you are not
decided.
So you are not saying any particular method, but you are saying it should be a scientific investigation. Only science and facts can decide whose argument or whose claim is right, and that can be justified. And that power is with the ASI. Now, Harishankar Jain ji, now please tell me, what does the order of the Allahabad High Court have any bearing in that case of the old case which they have called the 1991 case, where yesterday the court has asked the DG ASI to file a detailed reply in this matter, because this is the original case, Lord Vishweshwar versus Gyanwapi case, where the Sunni Waqf Board had gone and moved in challenging the April 21 order of a Varanasi local court ordering ASI survey of this entire Gyanwapi site. And the Allahabad High Court said this is a matter of national importance, so the DG ASI give a detailed affidavit. Do you think that will have they have given him time till they have given time till 18th October? Ji.
I want to point out that matter is different from the present one. Here, Shivlingam has been found only on 16th May, and that is regarding Adi Visheshwar, which lies at different place. Here is the Shivlingam found on 16th, and I pointed out just now that on 20th May, the Honorable Supreme Court is clearly passed an order. The case is transferred to London District Judge, who will be competent to decide all the applications, whichever is given. Therefore, the High Court proceeding which is pending has no impact on the proceeding which is going on before London District Judge. It is being governed by the order of the Honorable Supreme Court, and Supreme Court will prevail. Number two, there is no clash between the two proceedings. That proceeding is on different side. Here, very limited prayer regarding Shivlingam and what is beneath Shivlingam. That is very limited prayer. That is there. Therefore, you cannot equate both the things together. The High Court proceeding different, and here is the proceeding different. And again, I want to insist that Honorable Supreme Court has permitted by order dated 20th May that District Judge will be entitled, will be competent to decide every application.